Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is related to the assessment under section 153A and 153C for the searches which have been made before 1st April 2021. The law is very clear that if any document is found in the search of an assessee, then addition on the basis of that document can be done under section 153A, and if the revenue finds any incriminating material in the search of another assessee, then the addition on the basis of that incriminating material is to be done under section 153C. The question arises, if there are two searches, one on the assessee and one on the other assessee, and some incriminating material is found in the search of assessee and some incriminating material is found in the search of another assessee. So whether in that case two separate assessments are to be made against the assessee, or whether in one assessment, that is section 153A, the revenue can make both the additions. This issue has been taken up by Honorable Delhi ITAT C bench in the case of Vikas Jain versus Assistant Commissioner of Income Tax, and this case is reported in 123 ITR Tribunal, short note 78, and the date of the judgment is 23rd April 2025. The present case relates to the assessment year 2009-10, and in the present case there was search on the assessee, and on the same date there was search on another M group in which the assessee was a member. And in that search, some loose papers were found. From there, it was incriminating that the assessee has purchased some property from C amounting to rupees 2.6 crore. The assessment of the assessee was completed under section 153A, and in that assessment, the assessing officer raised a query that why the addition should not be made for this amount which has been paid by the assessee. The assessee said that the assessee has purchased that property for rupees 49.5 lakh, for which the assessee also submitted the bank statements. But the assessing officer made the addition under section 153A on the basis of the loose sheets which are found in the search of another assessee. This loose sheet was not found in the search of the current assessee, and there was no mention of this loose sheet in the Panchnama of the concerned assessee. When the matter came before the CIT appeal deleted the addition. When the matter came to the tribunal remanded the matter back to the assessing officer, and in the second round of litigation also the assessing officer maintained the addition, and now in the second round of litigation the CIT appeal also confirmed the addition which was earlier deleted by the CIT appeal in the first round of litigation. Now the assessee was before the tribunal, and for the first time the assessee raised an additional ground based on the Supreme Court judgment National Thermal Power Company Limited versus Commissioner of Income Tax, which is a 1998 judgment and which is reported in 229 ITR at page number 383, according to which an additional ground which is legal in nature can be raised at any point of time. The assessee raised the ground that my assessment has been completed under section 153A, but the addition is based on the incriminating material which is not found in my search but is found in the search of another assessee, which is also apparent from the Panchnama of the another assessee. When the tribunal heard this additional ground, the tribunal found that in the present case the CIT appeal has recorded a wrong finding in his order that loose sheet was in the search of the current assessee, but in factual this incriminating material was not found in the search of the assessee, it was found in the search of the another assessee. So addition cannot be made on the basis of that incriminating material under section 153A. If the revenue wants to make the addition on the basis of that incriminating material, then the revenue should have initiated the proceedings for that addition under section 153C and should have accordingly made the addition. So friends, this case not very expressly but impliedly gave a indication that when some incriminating material is found in the search of Assessee A and some incriminating material is found in the search of Assessee B, and the revenue wants to make the addition on the basis of both the documents, then according to this case, two separate proceedings against the assessee should be initiated and completed for sustaining the additions, that is 153A and 153C. At the end of this video, once again I am repeating the name of the case. The name of the case is Vikas Jain versus Assistant Commissioner of Income Tax, and this case is reported in 123 ITR Tribunal, short notes 78, and the matter has been decided by Honorable Delhi ITAT C bench on 23rd April 2025. Thank you, friends.